Thanks everyone for the opportunity to speak here. It's been great to hear all of the innovations in obviously digital health technology and data analytics that are changing healthcare and that landscape. At Greenberg Traurig, we have the opportunity to represent clients both in the US, domestically and internationally in this space, and really see the future of healthcare, and it's my pleasure to be able to do that. But we needed to give you a little taste of the regulatory landscape and how the utilization of all of that data, both the creation, storage, use, and access to it, is something that is being, has been and is being even more now at the forefront of the regulatory focus of governments, both the US and internationally as well. Pleased to have my colleague, Carsten, who's in our Berlin office, who's going to be speaking to you about the EU and UK regulatory landscape, and I'm going to give you a taste of the US front. Of course, we have, I think, 30 minutes or so to do that. We're going to be doing it at a fairly high level, but give you the opportunity to utilize these slides and make reference to them, you know, going for, there's our faces, nice. So these are the areas that we're going to, you know, touch on, but as I was indicating, the privacy trends essentially has become a geopolitical event. The concept of the privacy being on that world stage, and you know what it really means is that all countries around the world are really focusing in on how data is being collected, how it's being utilized, and even more so has come to the forefront as consumers. And their expectations of how their data is being utilized is obviously being triggered by public events, whether they be cybersecurity events and breaches. Everyone has gotten a notice that their personal data has been compromised because there's been a cybersecurity event, whether it's a bank or credit entity or a hospital. And so there's been a change in that perception. How the public is otherwise expecting not only hospitals and health systems and other players within the healthcare industry, but even on the consumer platform. We represent a lot of digital health tech platforms that are more consumer initiated. It's consumer driven, a number of products that have been talked about here on that forefront, and they're being subject to more regulatory restrictions and requirements as well, which we'll talk about. So what we're going to do is essentially talk through how this has progressed. GDPR, Carsten will talk about next, but how the U.S. has been following suit. The difficulties that the U.S. has been facing as this is now regulated at both the federal and multiple state level. And touch upon those states and give you an idea of where this is going. We don't have all states playing in this market yet, but soon enough we think that they will be, and we'll talk about the federal legislation that's being proposed to talk about that. So here's just a cool slide about the time frame and the privacy legislation that's coming out, what's to become effective at the state level. But let's take the time now to turn it over to Carsten to talk about the GDPR.
All right, thanks, Charles. So now, GDPR. First of all, before I get into the details of GDPR, it's important to understand that when we're talking about the transfer or processing of personal health data, in Europe, GDPR is one of several regulations and directives that may not apply. You probably heard of the NIS directive, there's a Medical Devices Act, and there's an electronic health data regulation coming up in the future. But for several reasons, GDPR is the most important aspect. Now, so let's go into the details while we're talking about GDPR. What is it? GDPR is a regulation that unifies the processing of personal data in Europe. By the way, Europe means, first of all, European Union, so the 27 member states of European Union. But it also includes more or less, to some extent, data processing in UK, in Switzerland, and in the other member states of the European Economic Area, which are Liechtenstein, Norway, and Iceland. So it provides you, from the business perspective, with a really good advantage of when you're doing business in Europe, you need to comply with the GDPR and more or less that harmonized law allows you to be in compliance with your data processing activities all over Europe. It has entered into effect in May 2018. And why does it matter? I think that's the most important aspect. Why do you want to be compliant with GDPR? Well, first of all, it has a really, really severe scheme of penalties. And if you have followed lately what happened on that front, you might know that a couple of months ago, one of the most drastic fines ever imposed in Europe was issued by the Luxembourg authority against Amazon, worth 740 million euros. And then some weeks ago, 2 other fines that are significant have been imposed against WhatsApp and against Instagram, worth 225 and 405 million. So that is a good incentive to be compliant with GDPR. But that's only one part of that aspect. The other part is if you want to extend your business to Europe and you're acting on the B2B front, that means you want to engage in business with European business. You can practically only do that business and allow those entities to transact and do business with yourself if you can tell them, look, whatever I'm offering you, the technical model, my business model is actually compliant with GDPR, and it allows you to be compliant with GDPR, because otherwise you may be fined if you use my services. So that's something you want to avoid. Who does it affect? GDPR applies to any entities that are processing personal data in Europe, no matter where the personal data originates from. But it also applies to non-European countries like US. If you are doing a business, or if you're offering your services to individuals in Europe, or if you're monitoring their behavior. Can we go on? Yeah. So these are some. It's a slide with the most important key definitions that you need to know. I'm not going to read all of that, but most important aspects, obviously, personal data. So GDPR applies to any processing of personal data. Personal data is more or less very similar to what you know in the US under PII. So personal identifiable information, and relates to any type of information about a data subject, about an individual. By the way, it also includes encrypted data. So just because you may be processing, let's say, medical data, health data, only in an encrypted way, it would still fall under the application of GDPR. That is important to understand. And you may have already heard of the concepts of responsibility. You have a controller and you have a processor. And controller is basically that entity that is processing data and who's responsible to it towards the authorities and the individuals. And the processor is a third party which a controller uses in order to have that data being processed. So a typical example is if you're coming up with a business, sort of like a technical business solution which allows clients or customers to have their end user data being processed through your system, you will be typically acting as a processor and not as a controller. And processing means more or less anything that you do with the data. It's really broad definition, it's really long, but in a nutshell, it means any type of handling of data will fall under the terms of qualify as processing, and therefore fall under the GDPR. So next slide. Again, a nice slide which more or less summarizes everything you need to know. If you know that slide, then I can actually go home, because that says everything you need to know about GDPR. I'm not going to the details of it, but maybe some words, or we talk about legal basis. That means that any type of data processing that you do needs to have a legal basis. So you need either to have the consent of the individual to process their data, or you need to be able to rely on certain other legal justifications, like you probably heard of the legitimate interest, or processing is necessary to fulfill a legal or statutory requirement, and so on and so forth. Individual rights, that's a big burden for entities and enterprises that are processing data, because that means that any individuals, without any reason, without any cause, may contact you, for example, and ask for a copy of the data. They can ask you to transfer the data to another company, and they have many, many other rights. And if you don't follow their rights and their claims, you may be fined. And I'm not going through all of those, but probably interesting aspect is data security and data transfers outside of the EEA, which require certain adequate measures. I'm going to talk about it in a minute. Can we continue? Yeah. So this is an extra slide which we prepared to highlight any sharing of health data. Important to understand is that the GDPR is sort of like a two-step principle and concept when it comes to the processing of data. All requirements apply to the processing of data per se, but when we're talking about health data, what the law calls them the special categories of personal data, then there are higher standards which we need to comply with. And those special categories of personal data include data about racial, ethnic origin, political opinions, by the way, also your trade union membership, but also data concerning health. So any processing of health data has a higher threshold in order to be compliant with GDPR. And that boils down, first of all, boils down to the question, may they actually share those data? What do you need? What is a legitimate justification for that? And that basically means you can only rely on consent. So whenever you're processing health data of an individual under the application of GDPR, you need consent unless you have really, really rare exceptions that apply. For example, if the processing is necessary for preventive or occupational medicine or necessary for public interest in the area of public health. But these are basically the only exceptions that apply. And I think for any telehealth providers that do business in Europe, one of the most important aspects is the data transfer mechanism. The European Commission and the GDPR has a concept which says any data transfer, any transfer of data, personal data from the European territory outside to the third country outside requires additional safeguards which need to be put into place, unless the third country has been recognized by the EU Commission as being as providing adequate safeguard. And that adequacy decision has been issued to various countries, but unfortunately not to the US. Data transfers to the US historically have been subject to self-certification regimes like Safe Harbor, which was quashed by the European Court of Justice, and then later the the Privacy Shield, which was again quashed by the European Court of Justice. And now we have a new self-certification regime coming up on the front. By the way, interesting enough, President Biden just released an executive order last Friday, which is supposed to pave the way to that new self-certification regime. But unless this has been adopted, the only legal way to transfer data from the US to Europe is basically having the standard contractual clauses in place, which is a standard contract being adopted by the European Union, by the European Commission, which the data exporter in Europe and the data importer in the US need to enter into to make those data transfers being legitimate. Yeah, I guess we can go on. Yeah.
Right. So the federal privacy landscape here in the U.S. is, as many of you are familiar with HIPAA and high tech, that is essentially, it's more limited, obviously, than the GDPR, right? It applies only to covered entities, which has a defined definition, and their business associates that they utilize to create, use, or grant access to protected health information. And high tech in decade plus now has otherwise created significant measures in electronic PHI, security management, and incident processes. But what you really hear about most of the time are breaches. In the event that there's a breach of that protected health information, some big or small, and the failure to mitigate and the failure to notify those individuals who may have been impacted by that breach event. So obviously, since we're limited on time, we're not going to spend much on this other than to say, because HIPAA and high tech itself are limited to a specific category of data and specific category of those creators or users of that information, there has been additional laws that we'll talk about both at the federal and state level that have been implemented. Many of you and many of the presenters here were talking about the interoperability, right? Access to patient information, the ability for individuals to obtain that information, as well as other entities to obtain that information. And so, from the Cures Act, and I know we had basically, if he's still here, obviously a government representative in talking about the Cures Act and the benefits of that law and the rules and regulation that have been put in place. I bring this to everyone's attention so they're aware of it, but the fact is that this law is now creating a requirement that electronic health information, which carries the same definition under HIPAA as far as a designated record set, it expands those actors who are subject to this law, who must store, permit access to, and permit, as we were talking about in the GDPR, those personal rights of individuals. And those actors are not only healthcare providers, which has a broader definition, but also health IT developers and health information exchanges and health information networks. One of the other things that I wanted to highlight too is the exceptions. Basically, the law says any type of activity that blocks someone's access to that information is inherently suspect. So, these are just examples of the exceptions to what would be inherently suspect. I wanted to point out that exempts certain fees. I was at a conference a few weeks back, and someone suggested that there fees that were otherwise applicable under HIPAA and other state laws would be no longer permitted. Well, that's not true. If you really actually read the definition of fees and the exception there, it's actually pretty broad, and still permits the ability to charge those fees. It's just, let's say you've already adopted a portal where patients can otherwise access that information. You've already expended the resources on that. Well, then at that, and to have access to that, you're not going to be able to charge them under this law. But it doesn't mean that if you need to go and create and have access to your system that otherwise doesn't have that interface or that's easily implemented, or otherwise they wanted a copy of their information in a format that is not otherwise the electronic access in the way that the law is otherwise created to allow, you can still charge fees. So, and by you, I mean the actors, right? The healthcare providers, the health IT developers, and so on and so forth. So I think that's something to be discussed for a little more in depth, but that's something that I heard from a conference, and I wanted to highlight it to this group because I delved into all of the federal regulations for that reason. Now, what I was talking about before was the fact that, and I'll provide some detail on it, is that states have taken the initiative to implement laws at the state level for personal rights, protection of that data, California obviously being one of the most prominent. But because of that, there has been initiatives at the federal level, and one of the most prominent of those initiatives is the American Data Privacy and Protection Act, which is just a bill, and it's just been introduced. It's not, it hasn't progressed since it's been introduced this summer, but it's intended to not go so far as GDPR. I wouldn't say because that's a fairly complex law. But it does, in fact, try to create this framework at the federal level for personal rights and protection of that personal data and access to, and officially, having affirmatively opt out and so on and so forth. Well, what's really important is because it's at the federal level, it's a bill that attempts to and would preempt certain state laws, as they exist today. The reality is, and what we're really here to say, is that how you're operating in the markets, and depending on where you're operating, you're going to be subject to numerous regulatory environments. And this is a law that otherwise is intended to address that as more and more states in the U.S. continue to adopt laws for those reasons. So, like I said, we can't get into everything. I'm going to run through these 5 states there, and starting with California. Many of you may be familiar with the California Privacy Rights Act. It amends and expands upon an existing law, which is a California Consumer Privacy Act, which was adopted back or went into effect back in 2020. This CPRA will go into effect January 1st, 2023, and it creates additional new rights and imposes additional obligations on business that are not just within the border of California, but doing business within with the residents within the state. Again, interestingly enough, it continues to borrow from the GDPR by adopting and introducing new principles that didn't exist under the previous law. Almost getting to be as stringent and complicated as the GDPR, but I always rely upon my friend whenever my clients have questions on that space. So here's a nice little glance. Again, a lot of this is for your reference, for you to be able to look back on and understand what your obligations are going to be when you're interacting with individuals within California. This is the again, like the GDPR, there's certain information that's sensitive personal information that has higher categories of rights and restrictions. But what I wanted to point out here is something that, as a lawyer, we're always advising on, like what do you or don't you know about when you're entering into contractual relationships with your vendors. There's going to have to be terms within your contract with those vendors that they're going to be compliant with these laws. And not unlike GDPR, which is a different framework, but sort of similar to a business associate agreement. When you enter into an agreement, business associate, not only is the business associate subject to those laws under HIPAA, but now you have a contractual obligation to enter into agreement and say, we are going to define the rights and obligations between each other. This imposes that. So you may need to go revisit your agreements with your vendors as this law comes in effect on January 1st, 2023. Again, here's just a breakdown of the personal rights that are being representative in the law in California, and it's just a reference tool for you to be able to go back and look at. So there's other states have followed suit, right? And this is the whole issue behind the complexity behind the U.S. Depending on where you're operating, and if you're doing a 50 state operation in practice, you're going to have to understand that these laws either are in place right now or will be effective down the road, and you'll need to come into compliance with them, assuming that federal legislation doesn't come through, and assuming that these state laws aren't more stringent in those specific categories that may be exempt. So again, no reason for me to go through all of this. This is key takeaways for those laws in Colorado. Again, this one, of course, it's trying to align with the California, but there's not consistent alignment from state to state. Right? Connecticut itself has and tries to mirror some of those provisions within Colorado and California, but there are differences that are relatively subtle and some that are pretty significant. And as you move through Utah and Virginia, I got to tell you, I rarely have clients ask me questions about Utah and Virginia, but they are becoming Utah for sure. Our firm just even opened up an office in Salt Lake City a year or so back. It's becoming a very large market. I find it interesting that Utah is one of the states that has gone and made that effort as compared to other states that have highly regulated environments. But Utah, does take a little bit of a lighter touch to it than the other states. And then Virginia itself, again, another state that has adopted and will come into place. If you look back at that schedule, will come into place, I believe they're 2024, and as they go through. So, these will continue to evolve. These laws at the state level will continue to evolve. A lot of them, again, are not consistent from one to the next, and you have to understand the variation between those.
Okay. Now you already heard a lot about regulation, about privacy regulation in the US on federal state level, about Europe on the GDPR level. And now I apologize for talking about a little bit more about a regulation. Now we're talking about the UK, the new UK Data Protection and Digital Information Bill, which is quite interesting. Why? Because it was only being put forward some month ago. And it may have the effect, we don't know how it would play out in the future, but it may have the effect that the UK data privacy regime will be diverting from what they currently have as inherited from the GDPR. So as of now, when you're doing any data transfer, any data processing activities which relate to the UK, and that activity is compliant with GDPR, you can assume that's also compliant with what's required in the UK. And that might change in the future because UK has decided to divert away, to move away a little bit from GDPR, with the intention to become, I guess, more independent, to show that they're not part of the European Union any longer. But also the idea was to put away certain requirements under GDPR, which are regarded by UK lawmakers to be too burdensome and which should be put away. I don't think we need to go into the details, but interesting would be, for example, that the subjective definition of personal data should be introduced. So as of now in Europe, any personal data which is principal is, there are exceptions, but the principle idea is anything is personal data if that data can be linked by anyone to any individual. So that's a standard idea. And even if you have no means of connecting certain information to an individual, it will still be regarded as personal data, which falls under the application of GDPR. And that will, and UK will move away from that if that bill is going to process and move forward. And yeah, some other aspects that might make it easier for business to do business to process data in the UK. But as of now, I think what's interesting to understand is that UK might be different from GDPR in the future.
So here's a helpful comparison slide. This is, you can again reference materials. I believe you all have this material, so you can go and take a look at it. That we just thought would be useful as you're comparing these laws. Our firm as a whole, we have people use the word robust. We have a very prominent data privacy and cybersecurity group. We were ranked #1 in Chambers. Carsten's actually going off to Chicago tomorrow to present, on these issues. We have a website that's constantly updated on these changes and developments. We have resources on our website. So happy to share that type of material with you. It's complicated stuff, but reference materials and the like really helps digest it, give you a path to understanding, that regulatory framework that's out there. We were going to go through a case study. I know we're over time, so getting a head shake now. But I want to say Carsten and I are doing extensive work in clinical trials and specifically decentralized clinical trials, utilizing remote patient monitoring, utilizing telehealth and the like, and all of those digital health technology. But what was more interesting is you have to understand the data that's coming in on the front end, that data that's coming in is compliant, that you can use that information because there's regulatory frameworks on how you obtain it up front. And then it also pertains to how you can actually utilize that data on the back end, which many people are familiar with the FDA and the common rules on human research and that piece of the puzzle and getting that informed consent. But there's also now, you have GDPR compliance, you have HIPAA compliance, right? There's a lot of practices out there that are just engaging and acting in these sites and being principal investigators or what have you. The way that they conduct themselves, the way that they pull patient information, the way that they recruit subjects into those studies is subject to all of these laws. And so I just want to emphasize that because we're advising that on a regular basis. And some of these state laws may trigger that as well. So thank you so much for the opportunity.